2022 before Justice Sir Jeremy Cooke. The hearing is being held by way of video conference in the DIFC courts in Dubai. Any orders or directions made during or after the course of this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by Watson, Farley and Williams Middle East LLP. Lead counsel is Ms. Charlotte Bijlani. The defendant is represented by Al Jalaf Advocates and Legal Consultants. Lead counsel is Ms. Amna Al Jalaf.
Yes.
Good morning, sir. Rather late, I'm afraid. We filed a skeleton argument, which had to be prepared very quickly. So it's not really elaborating on points as much as you'd expect, but I just thought it might be helpful as some form of guide.
Yes, I've read that.
I should also apologise for the late service of our statement of costs.
Yes.
If I could just deal with a few matters before addressing the submissions and evidence presented by the respondent. And I'd like to start by going to your order on Monday, which is at tab A29 of bundle part 1 of the bundle. And you may recall that the first order you made was that the claimant be permitted to inspect the Jebel Ali Free Zone Company's register.
Yes.
And so I'd like to take you to page 542 of the bundle.
All right, bear with me. Yes.
Which is the Memorandum of Association of the Respondent Company. And you'll see on the left-hand side at item 3 that the registered agent is stated to be Al Jalaf Advocates and Legal Consultants, the firm of which Miss Al Jalaf is the managing partner.
Yeah.
After the hearing on Monday, we requested Miss Al Jalaf several times to provide us with a copy of the company register. We also wrote to the registrar at JAFSA, but as at today, we haven't been able to obtain a copy of it from the registrar. They say that they have said to us this morning that they will send it to the DIFC courts in 2 to 3 days. Ms. Al Jalaf has refused to provide us with a copy of the register, despite being the registered agent of the company, and has failed to disclose it to the court in the with the submissions and evidence that were filed late yesterday. We only received all of the documents that have been submitted on behalf of the respondents in hard copy only at 4 p.m. Dubai time yesterday. I'd also like to raise a point about the appearance of Miss Al Jalaf as advocate. You may have seen from the documents that the respondent submitted. So you've got, first of all, the respondent submissions at running from page 353 of the bundle. And then you have a first affidavit of Amna Al Jalaf starting at page 414. And then a second affidavit. I've just lost the page for that.
Yeah, well, I've read both of them.
Yeah. Miss Al Jalaf is clearly giving evidence before the court and appearing as an advocate, which I believe is contrary to the duties owed to the court under the rules for practitioners applicable in the DIFC.
Well, where there are issues of fact, that's certainly true.
And the rule is at page 185 of the bundle, for your reference.
Yes.
So I'd also like to refer you.
Somewhat
sorry.
more interest to me is the fact that the power of attorney gives her power to represent both the company and Mr. Abu Hashima, who
Yes,
says
I was going to take.
who says he's got nothing to do with the company.
Yes, I was going to take you to that next at page 546, where
Yes.
it clearly says that he is Mr. Al Hashima is a member of the board of directors of A&K Trading Limited,
Yes.
and that power of attorney appears to have been signed on the 22nd of January 2022, the very day that we believe the aircraft left Dubai. And so I would like it on record to know whether Miss Al-Jalaf or anyone in her firm had anything to do with the leaving of the aircraft from Dubai, whether or not it includes corresponding or dealing with authorities, including the GCAA.
Do you want to respond to that, Ms. Al-Jalaf?
Yes, I do. First of all, I received instructions as an advocate and legal consultant in the day I received the power of attorney. So I represent in this case the A&K as an advocate and as a lawyer registered in the IFC.
Yes.
I've been receiving the power of attorney from Mr. Ahmed because Mr. Ahmed, he's still in the register in the A&K company. And as I stated before, that the company, the share of Mr. Ahmed was already sold a long time ago, but is not reflected in the company registry.
Yes. And what's the explanation for that?
It just need it was many other transactions happened during that period between the time of in the 21st of April when they signed the share and purchase agreement of the aircraft, and until October there was default from the operator to register the aircraft under the name of the new owner. And there was a lot of transaction happening that day and that time, and that therefore the Mr. Ahmed sold his shares to new shareholder, and it takes time to reflect in the book. There was some an inquiry to reflect it, and today I'm requesting the court to give me an order in order that to reflect the new shareholder to be registered in the DAFZA to reflect the reality of the owner of the shares in this company. I also need to emphasize that the freeze.
I don't understand what you're saying, Ms. Al-Jalaf.
What I'm saying is
if there was a transfer of shares and resignations from the board of directors and appointment of new directors, all of that should have been filed in the registry within a matter of days, or possibly weeks, but not months, not 8 months, 10 months later.
No, I think as a respondent for the company, I think the agent, they didn't receive any instruction to transfer recently, but they was in the process in order to change the shareholder, and we received recently, before we aware about the freezing of the aircraft, that this is the intention of the shareholder, the new shareholder, the old shareholder, to change the registration by adding the new shareholder in the company registry. because all the share is not sold in the same time. There is a lot of it in between, and I already put it in my affidavit, in the first affidavit, how those share was sold in batches. It's not sold in the same time and date.
No. I've read all that.
Yeah.
The documents you've produced don't support everything you say, because obviously you appear to have got your documents from Mr. Abishima, but there's still no excuse for not registering those matters, and the fact of
but this is not
as a matter of
But this is not changing the fact the new shareholder, they are the new shareholder of this company because they already transferred.
I understand that may well be the case, but I don't have sufficient evidence of that at present. But the difficulty is this, isn't it? That as long as the existing directors, the existing registered directors are on the books, and as long as the shareholders are on the books, they are responsible for the running of the company. In practice,
no, actually, in reality, there is a lot of documents the applicant already submitted. It shows that they are not the effective control of the company.
That may well be the case, but
and therefore, I think to ease everything, I don't think so. The new shareholder was object that they are responsible for anything, but we need to reflect this in the registry, which is I request the court in order to easy that I order the agent to change all the shareholder and reflected in the registry in Jafza.
Well, I'm not doing that today, because if that was to be done, I'd need to hear from those people who say they're the new shareholders. Who is ordinarily responsible for registering the transfer of shares? The old shareholder who sells the shares, or the new shareholder?
Both. I think they have to approach the agent in order to change it. And I'm happy that if you want an affidavit from any of those new shareholders, as I stated in my first, I'm happy to provide that. They are happy to do that immediately.
Well, your A&K and the existing registered directors are facing an application for contempt that was filed either yesterday or today.
Yeah, but we will go back to this point later on, because as I said, the order is not enforceable because the applicant, they didn't take any further action by requesting the Dubai court. This is outside the IFC, and they have to complete the procedure in order to get that application enforceable.
I'll hear what Ms. Biljani has to say about that.
Yeah, could I just point out that according to the document at page 418,
yes.
Mr. Kamal Abu Ali is supposed to be one of the new shareholders, and he is registered as a director on the register as at today, I believe.
Yes, but the reality is this, Ms. Biljani, looking at the matter in the round, it's everything is coming on too quickly without proper opportunity for everybody to address the relevant issues. And so if there's going to be an application for committal, it'll have to take place at a later date with a fair opportunity for all the parties concerned to produce whatever evidence they need. Let's cut things short for the moment. What orders are you actually seeking today?
Well, so I appreciate that the issue of the committal will have to be put off to another date, because I don't think we've, other than through Miss Adela, we haven't served Mr. Abi, and I think we just need to make sure that we bring the application to the notice of the person's concerns. So I'm really looking for a date for the consideration of the application for contempt, and we have had to, as you appreciate, pull together some evidence very quickly. We were intending to file a case for contempt against other individuals, but haven't managed to gather adequate evidence. So we would like an opportunity to do so. And I would have thought that a week is probably enough time, although I think the rules may refer to, I'm just sort of checking part relevant court rules, I think they refer to 14 days unless you direct otherwise.
Part 52 somewhere. Is that right?
Yes, sorry, part 52, 17. Unless a court otherwise directs, the hearing date of committal application shall not be less than 14 days after service of the claim form or the application notice.
Yes, well, there you are. I don't see any reason to cut that period short. There are plainly problems here about who's in control and so on and so forth, and those raise questions of fact that Ms. Al-Jalaf will have to have an opportunity to deal with. The fact that the registered directors are technically still responsible for the company is a matter which, of course, weighs in the court's eyes, but it's not the conclusive matter, because if they can't actually stop the plane from going, they can't stop the plane from going. And I need to have all the evidence in relation to that, in relation to any application for committal. But there's one thing I still need to ask Mr. Al-Jalaf to be quite clear about. As I understand it, Ms. Al-Jalaf, you are saying that you're authorised and instructed to act on behalf of A&K. Is that right?
No, I am instructed to act on behalf of A&K, and I am instructed by Mr. Ahmed because he is the only one he can give me power of attorney, not the new shareholder, because of the situation that they are not reflecting in the registry.
Right.
This is first. I also want to emphasize that again, sir, that the aircraft which is you freeze is no longer exist, because
this is nonsense. This is nonsense, Ms. Al-Jalaf. I simply.
This is very important, sir.
I won't listen to submissions on that, because it's quite clear from the terms of the order that was made what the aircraft was that was being referred to. The fact that it wasn't registered anymore with the authority in DIFC in the UAE is neither here nor there.
Sir, because
I'm afraid that point simply won't run at all.
I just want to share a point. An aircraft has an entity and registration number. So this is recognized internationally. If the aircraft has no registry, that means you put your freeze in the aircraft is not existing in the record and the General Civil Aviation Authority in Dubai and UAE, and also not recognized internationally because it's not registered and that under this name. The freeze, even if you want to take this freeze internationally, nobody will recognize it because the name of the aircraft is different. The entity, the nationality of the aircraft is different, totally different, and the owner of the aircraft also different. So you cannot freeze an aircraft with this name and consequence all the other things regarding the shareholders because of the aircraft left the Dubai. It's left Dubai because there is no freeze in that aircraft. And I think if the applicant want to address this, they need, if they go to the Civil Aviation Authority, there is no record about this aircraft anymore because it's moved from this record to the American record, FAA record. So it's registered there and have different nationality. So you cannot freeze an aircraft does not exist. And also
it does exist. It has the same
Mr.
serial
Johnny,
number.
no, it's not exist story, because there is, if you go to any international registry and put the name, you will not receive any details of this aircraft. That means it's not exist. Even if you go to IR registry, you will not find it under this register name because it's not exist. Government is not responsible about all the consequence of this order because the aircraft does not exist in their record.
If any of the directors or any of those who are bound by this injunction want to come to this court and say they did not know what aircraft was being referred to, they can do that, and I will listen to them.
Okay.
But I regard such a proposition as untenable. It is not possible for anybody who was served with this injunction not to know what aircraft was being referred to, whatever the registration number and whoever it was registered with. And it's just simply not feasible. And so if they were troubled by the fact that it didn't exist because of the registration number, they should have come to this court and they should have said so, instead of which they removed the aircraft. So that's a matter we'll have to deal with in due course.
As I said before, I
know what you say. I've got your.
If you want the director, the existing director, to come and say that they are not aware about the moving of the aircraft,
that's a different thing. That's a different proposition. I understand that point.
Yeah.
But the point that they didn't know what aircraft was being referred to is just nonsense, I'm afraid. It's perfectly clear what the aircraft was, and anybody served with this notice would know.
Yeah, but the order, if you take this order, if the applicant take this order and follow all the procedure and get an executed letter from Dubai court and go to the authority in order to stop the aircraft from flying, they will say we don't have this aircraft anymore. We don't have this name of
I'm not very interested in what the civil authority thought. I'm interested in what the directors and those running the company thought.
As I said, because of the current situation, the new director, they are not the effective control of the company.
I understand that, and we'll have to deal with that point.
And therefore, I request you, if you want a new shareholder be in the picture, I need an order that to reflect the new shareholder in the registry.
I don't understand that. As I
mean that because the agent, they cannot change the registry because of your order. We need a permission from.
I can't make any orders at all until I know what the true position is. And I don't know what the true position is.
I already submitted a document that those are the new shareholder.
Yes,
well, I already submit all the evidence of that. I put an affidavit for that.
Yes, but it's not sufficiently clear, I'm afraid, because we don't have anything from the new shareholders. We don't have the position of Mr. Ali properly covered. I don't have documents that show where he stands.
Mr. Ali is not a shareholder either. There is in the end there is only two shareholders. The aviation house. If you go to my affidavit in the first affidavit, is mentioned clearly that the new shareholders is only two.
Right. Well, you'll have to get someone who's not a lawyer to go on affidavit with adequate evidence of all the changes of shareholders.
Okay, then I request that.
Wait. This matter is going to have to come back before the court, as I say, because you need adequate opportunity to address the points that are being made. I want to have proper evidence from all sides as to what the state of play is, as to who the shareholders currently are, and above all, who the directors are, and above all, who actually controls the company and who made the decision to move the aircraft.
Okay,
those are the points that need dealing with, and why an explanation for why there was no registration of the changes of shareholders or directors, which have happened.
I can respond to that. They were in the process to do that.
Well, I don't understand this. This all happened months ago. April 2021, we're told there was a sale, and we're told that with effect from, and I don't know what date the resignation was, but it's said to be with effect from the.
But then resignation already sent to the applicant.
Yeah, maybe that's not the point, is it? I need to have the whole position clear on affidavit with evidence, supporting documents from those who are involved and not from the lawyer.
Okay.
So that's got to be covered. And I say, you only have to read your affidavits to see their gaps. I've been through them and looked at the sequence of sales and directorships, and the position is not adequately evidenced, particularly as regards Mr. Ali. And no doubt that's because you're getting your instructions from Mr. Abu Hashima. This is all very unsatisfactory. On whom have you served the application for contempt so far, Ms. Biljani?
It's been served on Ms. Al-Jalaf this morning. It was only issued, I think, this morning.
Yes,
it's also been served on Mr. Abu Hashima and Mr. Shendi, who's addressed in the evidence that's been filed on behalf of the applicant. It has not been directly served on Mr. Ali. I don't believe we have any direct contact details other than I believe the applicant has a telephone number for him, but always contactable on WhatsApp. But I need to just double check that.
Yes, and so far as the service of the freezing injunction was concerned, who was that served on in relation to those who are described as the new owners?
So the second affidavit of the Mr. Khaldoon has a statement at the end dealing with. I'm just trying to locate it. 293. Listen. Too early. One moment, please. Yes, sir. So at page 302 is exhibit KG2, detailing on whom the order has been served.
Yeah.
So it was sent by email to Mr. Abu Hashima. Mr. Faris Deeb, I believe, well, sorry, Aviation House is
Where am I looking at in this affidavit?
It's just page, starting at page 303.
303, sorry. Right. Yes.
Okay, I believe one of the shareholders, Namir Al-Akabi, is operating Al Moko Group. And Faris Deeb, I believe, is, well, it's not clear to me whether he's a shareholder, but he purports to be the CEO and executed the trust documents that we referred to in the earlier hearing.
I haven't quite gathered who Constellation Aviation Services are. Who are they?
I believe that they are connected with Faris Deeb. I think what the respondent is saying, sir, is that Namir Abdul Hassan El Akabi and Aviation House are the only two shareholders.
Yes, that's what I understand
Yes.
her to be saying, certainly. As I say, the position of Mr. Ali is not straightforward, but
all the
I mean,
shareholders already sold their shares.
no, I understand what you're saying, Ms. Al-Jalab. Don't worry, I understand that point.
I'm advised that Faris
the
Deep
real
is sorry, sir.
No, go on, you go on.
I was just going to say, I believe Faris Deeb is the CEO of Aviation House.
Yes. Yes, Mr. Al-Jalaf's submission and the evidence that she's put before the court suggests that Mr. Deeb is the man who runs the show now. But you're not seeking any application, not making any application against him.
So we may well do so, but as at last night, we were not in receipt of adequate evidence. We were waiting to receive various information.
Well,
I didn't want to file a serious application without making sure.
No, I understand, but let's assume, for the purposes of argument, Ms. Biljani, that at the end of the day, Ms. Al-Jalaf can establish on proper evidence that both the shareholders and directors have changed despite the absence of registration. So that although technically the existing registered directors remain responsible for the acts of A&K, it's not as if this court is likely to think that imprisonment of people who have no control over the company which moves the aircraft is appropriate. You know, if Miss Al-Jalaf is right, then they are in default in failing to register the changes. But they don't really have any responsibility for the movement of the aircraft, which is subject to somebody else's direction. And the question ultimately is, what good is any of this going to do you?
So I believe that the law requires directors to take reasonable steps to ensure a freezing order is complied with. And I understand from the applicant, from conversations that were held with the registered directors directly, that they had no intention of taking any steps at all. They could have notified the Civil Aviation Authority and said, I'm a registered director, you must not move this aircraft. But instead they did, as far as I can tell, absolutely nothing.
Yes, well, if you want to make your application on that basis, then you can, and presumably we'll have to have the individuals in and they'll have to be cross-examined about what they did and didn't do. But on the face of it, the people who are primarily responsible, if Miss Al-Jalaf's evidence is to be accepted, Mr. Deeb and possibly his brother and the other the shareholder of Aviation House, whose name I've forgotten. Yes, well, there it is. I mean, I think you need to think through quite where we're going with all this. At the end of the day, we're talking about a debt from A&K, which they dispute. I've seen the correspondence in November where they have a number of claims that they say the managing agents failed to operate the aircraft properly and so on and so forth. None of which was disclosed to me at an earlier stage, was it?
So I'll have to check the affidavit, but I think we did say that there was some disputes raised. But if I could just say that the damages claim that is referenced in the submissions filed by the respondent yesterday arises by reason of the deregistration of the aircraft by the GCAA. And I'm instructed that that only came about because the respondent failed to provide evidence of who owned the company, and the GCAA therefore removed the registration.
Well, we've got a.
Can I reply to this, sir?
Well, wait a minute. We've got a document, haven't we, which shows the deregistration, so to speak. The certificate of registration has been revoked under the provisions of Article 68 by transferring the ownership of the aircraft without approval of the GCAA. That's what appears in a certificate of the 29th of November.
So, which page are you looking at, sir? Please.
Well, I printed this off, but it was exhibited to the respondent submissions, in fact. So it's, where is it? It'll be about page 367.
Oh yes, I've got it. I believe it's because.
Also, this document was present by applicant on page 131 before.
I believe that the GCAA needed to see who owns.
Yeah, no, I understand.
The aircraft, and because they didn't have the evidence, they deregistered.
Can I comment on this?
You can, but I don't know whether it's going to help very much.
Just to say, I think the applicant violated the management agreement because this is their responsibility to submit all the documents to the GCAA in order to reflect the new owner. They failed to do that. I was contacting Civil Aviation Authority yesterday, and I received that the Civil Aviation Authority sent a letter to the applicant, asked them to inform them about the new changes, and they failed to do that.
Yes, well, as I say, this isn't going to help Ms. Al-Jalaf, because there's a dispute as to why they failed to do that. They say they failed to do that because they didn't have details of the ownership of the new owners.
They have the details of the ownership because Gulf Wings Limited is also connected with the Gulf Wings Free Zone. They are all together in the same umbrella.
I understand that, but the question is who owns the new owners? Anyway, those are matters for another day, because we can't deal with those today, but they are matters that will all have to be brought into the equation at some point. I think all that can be done today, Ms. Biljani, is to give directions, isn't it, for the future hearing of any application for contempt that you want to make.
Yes, so I would just like to make one request, which is that the respondent provides us with the current copy of the register today. And I believe that that is in the possession of Miss Al-Jalaf as the registered agent.
We already submit everything, and you have the. You have it.
No, we don't have the register.
Don't have a copy of the registry, do we? What appears in the registry?
Okay, we'll do.
Yes, very good. Right. Well, what do you actually have in your possession as the agent, Ms. Al-Jalaf? You have access to the company's registry and what appears in the company's registry. You can go online and get it and print it off, can you?
Yes.
Yes, all right. So let's be quite clear as to what it is you want, Ms. Biljani.
And a copy of the register as it appears with JAFSA as at today.
Just as
showing
at today.
The directors and shareholders. I
would want to see all changes in it since April of last year, or if not before. What's the earliest date?
Just 1 minute.
What's the earliest date that's relevant?
It's needs 1 week in order to get all this information, sir.
Yeah, all right. Well, we'll come back to what time you need in a moment.
I suppose April's the relevant date when the letter was received, indicating the change, that there was going to be a change in shareholders.
Well, it goes back, doesn't it, actually, to August 2020, 31st of August 2020, is the date upon which Ms. Al-Jalaf has said there was a conditional share purchase agreement. So I think I would like to see copies of what appears in the register from the 31st of August 2020 onwards in relation to shareholders and directors.
31st of August 2020.
31st of August 2020. That's the first share sale agreement you've referred to, isn't it, Ms. Al-Jalaf?
Yes.
Yes. So
But
I want to see what's on the registry from that point onwards, as both concerns directors and shareholders. I have no reason to doubt that what you say is correct, but I just want to see that and be quite clear what the position is.
Sir, all the document where you talking about changing the shares, we received it recently. It's not before, yeah. And also, I'm repeating my request now to make it easy in this case that if we can submit all this document to reflect in the registry of the JAFZA, it will help a lot and limit the shareholder.
Yes. I mean,
I want your permission in order that we change the new shareholder to be reflected in the registry.
I'm not going to do that until I've seen all the evidence. For example, just looking at the documents you've exhibited, according to the documents you've exhibited, although you say the position is different, the current shareholders would appear to be Aviation House 32%, Mr. Al-Kabi 45%, and Mr. Ali 23%. But you've said effectively that Mr. Ali sold his shareholding and no longer has the 23%, which has gone to Mr. Al-Kabi, who has 68%. Now that may be right, but it's not exhibited.
Sir, I can submit this today to the court.
Well, let's do it all in a sensible style and get everything properly organized. So
I can't hear you, sir. Say it again.
I'm going to give directions in a minute with time limits for things to be done. So, and you can tell me how long you need to deal with this.
Okay.
So, yeah, go on, Ms. Biljani. I want to make a shopping list, so to speak, of the things that need to be done.
There is the issue of jurisdiction and the challenge that has been made by the respondent. I don't know if you want me to address you on that, or whether you.
Well, if you want to do so briefly at this stage, yes.
Yes. So I'm just turning to the relevant page. Maybe it's in, yeah, David.
Are you talking about the enforceability of the freezing order outside the DIFC? Is that what you're directing my attention to?
Yes, that's right. And I believe that the respondent contends that because of Article 7.2 of the judicial authority law in the DIFC, that there's an issue concerning enforceability of the freezing order because it hasn't been sent through the enforcement section of the onshore Dubai courts.
Yes.
The case of VIH Dubai Palm Jumeirah Limited Cayman Islands against Assas in 2017 is a case that considered the enforceability of an injunction issued by the DIFC courts, and it also dealt with issues of contempt. And at page 99 of Bundle B, you'll have relevant judgment of Sir Richard Field, where he states that proceedings of contempt are not matters for execution falling within Article 7.2 of the judicial authority law, and that plainly an injunction made by the DIFC court against a party based in onshore Dubai can be can be enforced by the onshore Dubai competent enforcement entities, but that, and then I think he goes on to apply the principles of English law which are very clearly that a freezing order remains enforceable and must be obeyed until it's discharged. So I think it's incorrect to say that the freezing order is not enforceable in the way that the respondent is putting it. It's a freezing order, it's an urgent matter, and the order's evidently got a penal notice on it warning the respondent of the consequences of not complying. If we had to wait for it to go through the Dubai onshore courts to be recognised, it'd be there forever, and it would defeat the purpose.
Where's the relevant what you say accords with my understanding, but can you direct me to the relevant paragraph of Justice Field's judgment?
Yes, so on page 95, at paragraph 78 of the judgment.
78.
And this is a case where, again, an injunction was not obeyed. He considers the law in England and that the order must be complied with until it is set aside. And then
yeah, well, that's
paragraph 8, yes.
But yes, go on.
Paragraph 82, he goes on to say that if English law is to be the touchstone of what the law on this subject is in the DIFC, that he thinks that the situation of the DIFC court stands to be equiparated with an English Superior Court of Record. And although the in personam jurisdiction of the court is limited to the subject matter gateways contained in Article 5A1 of the judicial law, the court's very wide jurisdiction to grant interlocutory injunctions under Section 32B and C of the DIFC court law and to deal with contempt of court under Article 32E and 43 of the DIFC court law is no less wide than the jurisdiction of the English High Court.
If the individuals who are the subject of the injunction are subject to the jurisdiction of the DIFC court by reason of a jurisdiction clause or something similar, then an injunction is effective, whether it operates within the DIFC or worldwide. That's the basic point, is it?
Yes, and at paragraph 93, there is a consideration of the position where those accused of contempt are outside the DIFC. And he says, so this is the fifth line down, if the DIFC court has in personam jurisdiction over the parties accused of contempt of court, it matters not if such parties do not reside in the DIFC or that the acts constituting the alleged contempt of court occurred outside the DIFC.
Yes, and just remind me what the basis of jurisdiction in personam is here.
That is Article 5.2 of the jurisdictional law. Let me just start. Which starts on page 29 of Bundle B. So under the gateway at 5A subsection 2, the DIFC courts have jurisdiction because the parties have expressly agreed that the DIFC court should resolve any disputes.
That's in a clause in the management agreement.
But this is non-exclusive jurisdiction, and we reserve our right about jurisdiction.
I understand. I understand.
Yes, management agreement provides for DIFC courts to have jurisdiction.
Non-exclusive.
That doesn't matter. Anyway, there it is. Right. Well, that's how I understood the position to be. So, all right. Now, the things that need to be done in order to get an application on. First of all, I say we must get the position clear on the shareholdings and directorships. So how long is it going to take you, Ms. Al-Jalaf, to get copies of the registry documents?
Registry will take 1 week.
Right. 7 days for registry copies since, what was the date? I said 20th of August, was it? 31st of August 2020, right? Okay. Now, apart from the registry documents, Ms. Al-Jalaf, we need to have evidence from those with first-hand knowledge, not yourself because you're a lawyer. You know there's a requirement as a matter of practice in the DIFC that lawyers don't swear as to disputed facts. So you're going to need someone who's instructing you to do that. Now, as I understand it, Mr. Al-Jalaf, and you need to tell me, the only person you're getting instructions from at present, am I right, is Mr. Al-Hashima, is that right?
Yes.
Not from Mr. Shendi?
No.
And, right. And what is Clyde & Co.'s position, Ms. Biljani, as at today, as to who they say they're acting for?
We received a letter from Clyde & Co. yesterday saying that they are no longer instructed to act.
Why is that no surprise?
Indeed.
So you have no instructions, Ms. Al-Jalaf, from Mr. Ali or from Aviation House Investment or Mr. Deeb or any of the people you describe as the new owners?
No, I clearly mentioned from the beginning, I'm instructed by A and K, represented by Ahmed, because his name in the registry.
Yes, well, I understand.
I'm not represented him in his personal capacity.
Yes, now I understand that point entirely.
So could I just raise...
Which means in reality, Ms. Al-Jalaf, that you're not going to be making submissions on behalf of A&K. It's only because he's still a registered director that you appear at all. Really, you appear for him personally rather than anybody else.
No, because he's the only one can give the power of attorney in order to represent the company for now, according to the book, to the paper.
Yes. Yes, I see. Well, what, Ms. Biljani, are you planning to do about any of the new owners?
Well, sir, I don't quite understand Ms. Al-Jalaf's position, because she must be dealing with, if the shares have been transferred, she must be having some dealings with the new owners, because she must have received the documents transferring ownership and had the request to change the register. Who's actually made the request to change the register?
No, I repeat again, all the documents I received just recently.
Because she's the registered agent for A&K, you mean?
Yes, that's right.
Well, I'm going to need some sort of chapter and verse about the responsibilities of the registered agent and the responsibilities, both as a matter of general law, as to who is responsible for registering changes of shareholders and directors in the ordinary way, if it works in a similar manner to what I would regard as universal practice, but certainly in the UK, you would expect the registered agents to be acting on the instructions of the old and new shareholders with documents that show a change of shareholding to then register the change, and likewise with directors with resignations and resolutions of notices of appointment. And you would expect all of that to be done in cooperation by the sellers and the buyers, and the registered agent to be instructed to file the necessary documents. Is that how you understand the position to work, Ms. Al-Jalaf?
I repeat again, We didn't receive any document until this case was filed and the Mr.
Yeah.
Hashima was contact us.
I understand that, but is what I've described the usual practice?
The usual practice, yeah. If there is any changing in the shareholder, the new shareholder and the old shareholder is supposed to send us a document in order to reflect it in the registry. This has not happened.
I understand. Okay. And I also need to know, Ms. Biljani, quite what the management agreement has to say about any of these matters. And in particular, changes of ownership, of course, of the aeroplane as opposed to anything else.
Yes. So I'd just like to raise a point. Ms. Al-Jalaf says that she hasn't received documents showing change of ownership, but she's asked permission that you allow her to make the changes on the register.
This is not
Yes,
correct. What I said, I just received it recently after the case.
Yeah, well, as I say, I'm not doing anything, Ms. Biljani, about that until I know what the position really is, and I see all the documents that show the changes of shareholding and change of directors, whether they be letters of resignation, whether they be notices, resolutions of the company or the shareholders as to appointment of directors, all the usual formalities that you would expect to see that would precede any registration at the company's registry. I need to see all of that, and that's what I'm asking Ms. Biljani to deal with. Now, how long do you need to deal with that side of things, Ms. Ms. Al-Jalaf, to deal with? How long do you need to deal with that? If you can produce the registry copies in 7 days, can you also obtain an affidavit from Mr. Abushima or anybody else which exhibits all the relevant documents that show the changes in shareholdings and directorships?
I think, yeah, I need 1 week to do that.
Yes, very good. All right. And presumably it'll have to be Mr. Abushima who swears the affidavit, will it? Because he's the only person you can get to do it, unless you can obtain something from the new owners, which would be ideal, would be to have something from both the old owners and the new owners.
I can try to get from both of them.
Yes. Yes. All right. Well, seven days then for whatever evidence you wish to put forward.
So could I make a request that we...
Well, hold on. Yes, I just seeing we've got 14 days before the hearing. Must be 14 days. Yeah, I'm looking at 52:12. What's the sensible order in which evidence should be produced in order to deal with your application, Ms. Biljani?
Well, perhaps it would make sense for the respondent to be given an opportunity to respond to the evidence we've submitted. Although I'm thinking that if we do file a further application and more evidence, then it will slow down matters. So maybe we should do a simultaneous exchange of evidence a bit later on, once we've had the opportunity to deal with all of the inquiries that are currently outstanding in relation to other individuals.
Yeah, I mean, I want to deal with this in the round. I don't want to do bits and pieces. I want all the evidence to be forthcoming, and I can look at it and decide what's appropriate. In one sense, the urgency has gone out of this because the plane isn't here anymore.
Yes.
And I haven't seen the evidence as to any other assets of the company in the locality.
The respondent did not comply with that section of the freezing order requiring them to provide an affidavit of ownership of assets.
I know, but you don't have any evidence of other assets?
No, we don't, sir.
Sir, can I point out also that
Yes.
the aircraft was registered and owned by another company, is not A&K, before the freezing also. So
No, I understand. I understand that point in theory,
yeah.
but the question arises whether the owner trust structure means that in fact A&K is still the beneficial owner, which is what it looks like. But we can cross that bridge when we come to it as well, if that's an argument people want to run. But if whether
So
they're the actual,
I don't know this either, because the new shareholder is not sharing anything with us, and they are the effective control in this.
well, we'll have to
within
deal
the
with
bundle.
that. We'll have to deal with that when the time comes.
Yeah.
All I want to do now is to establish the timelines for service of evidence and the pursuit of this application, and indeed any fresh application that you might decide you want to make.
So if I could suggest that perhaps if we have a period of up to 7 days to file any further application,
Right. Very
and
good.
then we could run the evidence from there.
Well, I'm going to make an order that within 7 days you file any further application that you feel is appropriate and any further evidence that you feel is appropriate. Within 7 days, I'm going to call him Mr. Abishima as opposed to A&K, but Mr. Abishima files any further evidence that he wishes to file. And in relation to the whole question of shareholdings, directorships, and control of the company, and that within 7 days, Ms. Al-Jalaf produces copies of the entries in the company's register in relation to shareholders and directors since the 31st of August 2020. And then what happens thereafter will depend on the application you make and what further evidence parties wish to put in. Ms. Al-Jalaf, the position on a contempt application is that you can put in affidavit evidence from those who are subject to committal, and they can come and give oral evidence as well and be cross-examined. Whether that's necessary will depend on the evidence that's filed.
Okay.
All right.
Yeah.
I mean, I can indicate this because I think it's pretty obvious, and I've already, I think, said as much. If the reality is that control of the company passed a long time ago and well before the events of the freezing injunction and so on, then obviously the position of Mr. Abishima is much less prejudicial to him than it would be if he was in control. But what Ms. Biljani is saying is that regardless of whether or not he ceased to be in control of the company, as a director who was still registered, he had responsibilities to try and do something when he was served with the order. And the question is, what did he do? Now, there's an affidavit that's been served recently that you've probably seen, the second affidavit of, what's his name?
Khaldun.
Khaldun yes. Yeah.
And you may need to deal with the points that are made there about the various exchanges in WhatsApp messages and so on and so forth, and what your client's attitude was. So those are matters for you to decide how you want to deal with them in any affidavit in the next 7 days. All right, okay. And then I think we'll review the matter once we've got to that point. I don't think there's any point in making any further orders beyond that until we see where everybody wants to go with it.
Okay.
Yes, sir. Could I just make one request, which is, could we have a copy of the online register of the company today, which is available to Ms. Al-Jalaf by simply logging on to the JAF's website as registered agents?
What appears today?
Yes.
Yes. Well, you said you could do that, didn't you, Ms. Al-Jalaf? You said you could do that today.
Yeah.
Yeah, very good. Will you do that, please? Make that part of the order as well. Ms. Biljani, will you draw up that order?
Yes,
and,
sir. Of course.
submit it to the court for approval?
We do.
And
Well,
then,
actually, we have an old one because my colleague who dealing with the registry, he said I'm not sure if we can have it today. We will try to log in and check what is available, but I think we have only the old registration. So
what does that mean? What does the old registration mean?
is the one when we registered the company previously, and when we renew it. If you can give me a minute.
Yeah, you could probably go online right now, can't you?
We have the one which is old as a year ago, which we can provide it. Since then, there is no any changes on that.
Right. Well, if
Not
you
from
could,
our side.
right. Well, if you can provide a copy of that today,
Yeah. Okay.
and then within a week, the other matters that I've referred to,
Okay.
and then the final provision of the order, I think, leaving aside costs for the moment, that the final provision of the order will simply be that the parties liaise after the expiry of 7 days and the exchange of evidence,
Okay.
and try and agree what the right thing to do thereafter is. In other words, do you need further evidence, or should a hearing date be fixed? And if you can't reach agreement within 3 days thereafter, the matter is to be referred to the court for the court to decide on future directions in the light of any submissions you want to make in writing.
Okay.
Is that clear?
Yeah.
Yes, sir.
And end of 7 days, parties to liaise with a view to agreeing directions. In the absence of any agreement on directions, parties to write to the court within 3 days, parties to write to the court with the submissions as to what direction should be given, and the court will then decide.
Okay.
And I will simply reserve costs for the moment, wait to see what happens.
Okay.
Yes, so obviously costs are escalating, and
Well, I realise that,
the,
but
the applicant's faced with a respondent who, regardless of the contempt of directors, it's faced with a respondent that has evidently breached the injunction.
well, there's no question that ANK has breached the injunction. The question is who's responsible for ANK.
Yes. Yeah.
I understand all of that. There was, at least in Mr. The second affidavit, some discussion between the parties as to whether or not some payments were going to be made or some settlement reached, which didn't go any distance. But the costs, obviously, of these applications will mount up very quickly in relation to what is not a huge sum at issue. But the parties are commercial parties, so they'll have to decide for themselves how they want to deal with that.
Yeah.
They want to waste their money on lawyers. That's a matter for them, I suppose.
Yes, sir.
That's where your interests may or may not coincide. Anyway, you're duty bound to give them sensible advice as to what they ought to be doing. It's obvious that a contempt application in the end doesn't achieve a great deal commercially for the parties. It's very unfortunate for all those concerned. Anyway, there it is. Anything else that I need to do right now?
Not from the claimant side, sir.
Anything from your side, Ms. Al-Jalab?
Not from our side.
Very good. All right. Thank you very much. If you'll submit a draft order, Ms. Biljani, to the court at the same time as to Ms. Al-Jalaf, in case she's got any problems with the way you've interpreted what I've said. And then
I don't.
Shouldn't have. And then I'll approve it and it can be issued.
Okay, thank
All
you.
right.
Thank you, sir.
Thank you very much, both of you.
Thank you.
Thank you. Bye-bye.